My ladies, my lord, as you can see, I...
Sorry, Mr. Wise, 1 minute. I seem to have left some papers sitting on my desk. Okay. Okay. You know, from my yellow pad. Yeah. Thank you. Sorry about that, Mr. Wise. It is a bit critical that I've left the judgment sitting on my desk.
Well, I can perhaps do the introductory part while...
Well, there's we've got some issues we want to raise as well.
I'm sure, my lady. Does your lady want to...
Yes, so shall I go first, and then you can do your housekeeping, so you know what you need to do with us. So the first thing is, thank you very much for all the additional material, which has actually all landed. We've all had an opportunity of reading the papers extensively in the case, which includes the proposed fresh evidence, as well as, of course, the Skelton arguments and the judgments and the court documents and authorities. We've seen that you've had a number of hearings, one way and another, in front of Lord Justice Dingemans, and we see that he gave you a sort of fail-safe for the matter to tip into tomorrow. Having read the papers and seen that we're actually now dealing with essentially 2 or 3 issues on 2 areas, we would anticipate that we'll finish comfortably today, but of course we're not, as I would imagine you all do as well. But we haven't actually taken it out of the list for tomorrow, just in case that safety net is required. Yes. But if you may want to have a quick word. I don't know if you've discussed between you how you're dividing up the time, but we hope we'll deal with the matter today. Well, if it's of assistance to that, so far as all the fresh evidence that's involved, a bit of yellow paper had my list and the dates, but you all know what they are also. Yes. We've discussed it at length, and we intend to consider all the additional witness statements on either side de bene esse. And then we can all focus on the very important issues that this court has to consider in the light of the appeal and the cross-appeal.
I'm grateful for that, my lady, and I'd anticipated that with sufficient pre-reading we may well finish today, but yes. There was a danger that it might have drifted into tomorrow, yes. But if we can finish today,
well, we've all done our homework.
I'm obliged for that. I did briefly speak with my learned friend, Mr. Lawson, prior to coming into court about the order in which we go.
Yes, well, help us with that.
Because there's precursor to that is that there is a timetable laid out. I don't know if that's reached.
No, it's not reached.
Oh, well, we did. Well, the original timetable was that I would be going until lunchtime today, and for the first hour this afternoon, then Mr. Lawson for the rest of the day, then him for an hour in the morning, and then my reply. But that's generous, I would say. But the really important issue, I think, in terms of managing the appeal, is the order in which we take the issues. Because obviously we've got the appeal.
I have a judgment.
Obviously we've got the appeal, the cross appeal, and the notice to affirm. So there's 3 issues that are before the court. The primary issue, obviously, is from the appellant's point of view, is the restitution. But of course, to get there, we need to establish the failings of the ICB prior to that. So the logical, it's entirely a matter for the court, but it may be that the logical way of dealing with it is to look at the care planning and precursor issues, if I may put it like that, prior to the restitution issue. So, but I'm entirely in the court's hands as to how you want to play that. But it does feel somewhat counterintuitive to be jumping to the restitution issue before we've established the necessary preconditions for the.
Yep, we're happy with that. If that works for you and everyone thinks that's a sensible way to proceed, we're entirely in your hands, Mr. Wise.
The issue then is the order in which we go, and the danger in these bills, and I'm sure all the members of the court have seen this, is that when there's appeals and cross appeals and other issues, there's a danger of switching between different counsel and so forth.
Speaking for myself only, and I'll see what the balance of constitution think. I'm never very keen on advocacy tennis.
On
advocacy tennis.
Oh yes, yes, yes. Absolutely. That was why I raised it. So if the court is content with that, then I propose to bat on with the 3 issues, and then we hear from a learned friend. I do a reply, and then if my learned friend has any further issues to raise that arise out of the cross appeal, then obviously we're quite content for him to make whatever submissions that he wants to do.
Mr. Lawson, what do you have to say about that as a proposed way forward?
My lady, that's fine. It seems Mr. Wise first, then me, then Mr. Wise, me, if I have something that I can persuade the court is appropriate for further submissions, essentially.
Yes, certainly.
And given your ladyship's indication a moment or two ago, I will endeavour to finish my submissions by lunchtime.
I would have thought you could do that.
In terms of housekeeping, if we can just make sure that we've got it. You should have counsel's list, incidentally. You'll see that I'm assisted by my learned friend, Mr. Percy, who sits behind me. Mr. Lawson, who we've already seen, of course, appears for the ICB respondent stroke appellant. I'll call it the respondent for present purposes. He's assisted by my learned friend, Mr. Rylett, who sits behind him. We also have in court Miss Bradley, who appears for Haringey, the interested party. She tells me that she doesn't intend to take part in the hearing, but she's here on watching brief or a noting brief. Which
certainly very sensible, Miss Bradley.
Miss Bradley appeared in the linked care proceedings. I don't know if you saw those.
I appreciated that. But have they completely concluded? Have they
withdrawn?
They
have. The local authority withdrew their application without there being any findings.
Yes. Oh no. Well, I knew there weren't going to be any findings. I didn't know whether they'd actually been withdrawn or whether it was anticipated.
That's right. We're just completing the last order, the final order, and the judgment.
Thank you very much.
I don't need to deal, in the light of what your ladyship's just said, with the application notice to admit the evidence.
Sorry, one more thing, Mr. Wise. I see. Is it the parents at the back of the court?
Yes. Mother sits at the end of the row, 2 rows behind me. Father sits at the back of the court with a family friend.
I'm glad they were able to come and be able to watch.
Yes, and so are we. In terms of bundles, just to ensure that we do have everything. There's a core bundle, of course, and we have 2 supplementary bundles.
Yes.
One of which is the post-Lord Justice Dingham's orders and so forth, and the applications to admit and so on, which we may have to look at. The supplementary bundle we almost certainly will have to look at. And the court should also have an authorities bundle.
We have all of those. Thank you.
So housekeeping having been done, can I just say I appreciate the court's done its pre-reading, but just by way of brief introduction, may I take the court initially to Mother's first witness statement, which we've got in the core bundle at page 134. I'm sorry.
You mean the supplementary
bundle? I'm confusing myself.
That first supplementary bundle, isn't it?
Yes. Yeah, page 134. This is Mother's first statement at the outset of the application coming to the court. And you'll see in the very first sentence on page 134, she says, the court will see that this application concerns the planning and delivery of essential life-sustaining health care for the claimant, Amric, who's an 11-year-old boy, now 12, of course. If we can just turn over the page, the court will see at paragraph 2 that the child has an extremely rare genetic disorder, which is life-threatening and life-limiting, and has a severe learning disability, communication and mobility disabilities, as well as severe uncontrollable and potentially fatal epilepsy, which is typical of his CTD condition. And if we look at the bottom of the page, picking it up on the last line, if I may, when supported in the right way, Mother says he's an incredibly happy boy. He's proud of his achievements, advancements and achievements, and likes nothing more to be commended on them. And importantly, paragraph 4, the court will see that the child brings his father, Matthew, and me, as mother, such joy and happiness. But of course, caring for a child who is so medically complex and fragile is also incredibly hard and challenging. And then if we can just take it over to page 140, paragraph 10, we get a little here about, we get some explanation of the child's medical condition, and you'll see, picking it up at the 5th line of paragraph 10, when diagnosed, that there were only about 100 cases identified worldwide of the disorder that this child has, so an extremely rare genetic condition that this child unfortunately has. Mother goes on to explain a little bit about what the nature of that disorder, the disorder is, and then clarifies at 11, goes on to say that this deficiency is a life-limiting and life-threatening disorder. Importantly, if we go over the page, also in paragraph 11, picking it up at the 5th line, sentence beginning also, even before his diagnosis, the child was identified as having the most worrying type of epilepsy in regard to potential SUDEP, that's sudden unexpected death in epilepsy, and he has early onset epilepsy, prolonged seizures, nocturnal seizures, aggressive convulsive seizures. And that's by reference to his consultant, Dr. Petropoulos. And you'll see in the succeeding paragraphs the length that the family have gone to looking after him. And at paragraph 22, final paragraph, page 149, she concludes by saying, we remain open to any suggestions about how to resolve the issues leading to this litigation and have made this clear in correspondence, that these issues require urgent resolution, etc. And as the correspondence reveals, the mother has taken every opportunity to try to resolve this matter without having to come to court, but unfortunately the resolution, of course, hasn't been possible.
Thank you for that, Mr. Wise. For my own part, I have, of course, read that document in full.
I'm obliged, my lady, but I thought it was important just to emphasise that at the outset. I shan't go into the further background, the complex areas about what happened with regards to the care package and what have you. We've got that in the judgment of Mr. Justice MacDonald, and I don't need to take you to that. But there is one other document I would like to take the court to, if possible, by way of background, and that is in Mother's second statement.
Yes.
That we've got at page 210. She explains her financial position at that time, but for present purposes, I want to take the court to the report of the treating consultant that's exhibited to that statement, that's found at page 221. This is a report...
Sorry, 221?
221.
Thank you.
This is a report from Dr. Petropoulos of September 2024. It's not a long report, it's 5 pages long, I think. And what she sets out at page 222 is the summary and list of diagnoses. And you'll see there that there's a whole list of conditions and difficulties, medical difficulties that this child has, including, but not limited to, the genetic disorder that we've already seen, which is life-threatening. So I'm at pains to emphasise that that is just one of a whole host of medical difficulties that this child has to contend with. And if we look over the page, towards the top hole punch 223 regarding Amric seizures. The doctor says, in line with his condition, the child experiences a range of different seizure types, the most worrying of which is prolonged convulsive events. Looking at the London care records since last September, so that's September 23 to 24, there were 7 London Ambulance Service call-outs, 2 involving the same illness, etc. So that gives an indication of the seriousness of the seizures. And then if we go over the page 224, what she says under the heading towards the bottom of the page, is there an issue of pain management? Parents have consistently reported that pain in the child is more likely to provoke a seizure, and pain is a known trigger for seizures. So you get the building up the picture of a very fragile and vulnerable child indeed. And finally, can I take the report over the page to 225 and the other comments that the doctor provides? She says, I have treated A since he was 4 weeks old. I'm familiar with his condition and I've witnessed how his parents have cared for him, researched his condition and advocated on his behalf over the years. And then she goes on towards the bottom of that paragraph. That's the parents who prioritise the child over themselves. And as a result of the court proceedings, that's the family proceedings, observed a significant decline in both parents' physical and emotional well-being, and resolution of any disagreements about the care package. So you can see there a picture of an extremely vulnerable child.
Just looking for
Finally, by way of background,
and this was September.
September 24. So that was fairly current at the time when the proceedings were issued. That's Dr. Petropoulos. And then take you to the third statement of mother, which is at, I don't know if your bundle's a tab, but it's tab 15 in my bundle.
Sadly not.
Well, page 249 of the bundle, my lady.
Sorry, I was just writing that down. Third witness statement, got it?
Yeah, 249.
So this is November.
Yes, so this was a statement after the hearing in the High Court, and it's concerned with the financial position, which is obviously highly relevant to the restitution issue. I can just pull out a few points, pertinent points, if I may. If we go to paragraph 4, page 250. We see there reference to the child savings. He has in the region of £32,000 is in the account. I don't have the exact figure. This is not an account which I have access to online. Apart from the legacy from his grandmother, the rest of the money in his account will now be withdrawn and put towards the cost of his care. Both the cost from the 10th of July to date and the cost going forward now have to be met. Because there was some confusion at the time of the hearing in the High Court, but although there have been invoices paid, the money actually hadn't been transferred, but there was obviously the liability. By this time in November, it had become clear that they were going to be using some of the child's own money, and that does somewhat change the matter in that the restitution now is not just for parents' money that's been expended on child's care, but also the child's money as well. That was information that wasn't available at the time of the High Court, and is obviously a development. Mother then goes on in the succeeding paragraphs to explain the sums concerned. Second sentence of paragraph 5, we will use £31,000 or thereabouts from the child's A's account towards the total, which currently stands at approximately £198,000. And then...
But Mr. Wise, just help me about this, because I see this, and these are huge amounts of money for an ordinary family.
Yes.
But I'm not sure how the quantum helps us in determining the issues we have to
No,
determine. It's the fact of the payment as so far as...
or £250,000. I agree. The
I'm
principle
not
is
sure if
exactly-
that this where this is taking us. Apart from, as I say, we understand completely the inevitable impact
Yes.
these sort of figures would have on any family. But
Yes,
I'm not sure otherwise.
Well, that's what I'm trying to. That's what.
Well,
that's
we
what
have
I'm
the
trying-
point.
I'm obliged. And
And I suppose that as to £31,000, you've got the point that that was the child's own money.
exactly, my lord. Yes.
That's, I mean, that is-
Relatively
that
minor.
itself is a lot of money, but in the overall scheme of things,
Yes,
that's
relatively minor in the scheme of things. If I may, just one sentence, lady. Paragraph 8, you'll see that they've had to liquidate investments to pay for this.
It would be very surprising if they'd had it in a current
It
account.
certainly would. And the cost of the care package is now in the region, the liability now in the region of £350,000.
Mr. Wise, we have the point.
Yeah.
Is it still? It's still being privately funded, is it?
Yes.
As we sit here now.
Yes.
Is it not a resolution?
Yes.
At ground level.
We don't have the evidence before us because it's literally changing by the day, and I'll stand corrected by my learned friend if I'm wrong. But my understanding is that it's hoped that a care package will be put in place starting on the 17th of this month.
So that's an agreed care package by new providers, which will relieve your lay clients
Hopefully.
from paying.
Yes. That's the anticipation as we stand to.
Or if I say, even if there's still, if it's not wholly agreed, it's anticipated there should be some
That's why I use
sufficient
the word
agreement to
anticipate.
allow
Yes.
at least the drain on this family's resources to
Yes.
come to an end.
Yes. I'm obliged. Sorry if I've laboured that a little bit. I just wanted to make those points.
All right.
The court will, in terms of the proceedings, the court will have seen that it's important to emphasise that the care was withdrawn on the 9th of July 2024. Or 9th of July was the last day that care was provided by the ICB, so there was no.
So the
care.
cost started on the 10th of July, 2024.
Absolutely.
Can I just to pick up one point? You mentioned the figure of 350,000 just now, and is that per annum or is that the cost to date? Which
Cost
the
to date.
parents say they are out of pocket. So that's the figure.
Cost of it.
Thank you very much. Thank you.
And all this started, as we just identified, on the 10th of July. Judicial review proceedings issued on the 15th of August, so with the pre-action.
We've got a chronology, haven't we?
Pardon? We
have a chronology, haven't
Yes,
we?
you do.
We have that, thank you. It's
and
35
then-
of the core bundle.
The hearing before Mr. Justice MacDonald was on the roll-up hearing on the 20th of September. So things move very quickly. As you will see, there was 3 grounds advanced on the claimant's behalf. There was the unlawfulness of the care plan, the rationality of withdrawing the care, and the restitution issue, which the judge characterises as a remedy rather than an issue in the case. It doesn't matter how we categorise it. And as the court sees, A succeeded on the first issue and didn't succeed on the second or third issues. Lord Justice Dingman, granted permission with respect to the restitution issue, which is clearly an important and discrete point of law that arises from this case.
But it would link, wouldn't it, with whether you succeeded on issue 2?
No, my lady, we pursued that before Lord Justice Dinkman, and he was adamant that issue 2 added nothing, because if there was an unlawfulness with respect to ground 1, then ground 2 didn't make any difference.
Well, I'm afraid we're not tied by that.
That's
not a judgment.
Absolutely, but that was certainly it was pursued. Permission to appeal was sought on that.
Mr. Wise, can we invite your clear focus on that, because it might be thought there's a causation issue of some difficulty. If you hold your win on ground 1, that
Yes.
means there was an absence of a healthcare plan at the relevant time.
Yes.
But the restitution claim is predicated, as we understand it, on the rejection of the ICP's alternative, and the maintenance by your clients of the need to self-fund the existing provision.
Yes.
And it might strike somebody as difficult to connect those two propositions. So when you get to it, which I'm sure you will, could you please focus on that as a point which we are very interested in?
Certainly, my lady. Yes. But regardless of that, with respect to the issue on which the judge below did find for us, if this court rejects the cross appeal, then it may not be necessary to uphold his decision on that point, i.e. on ground one, for the other grounds that we've advanced that he should have done.
But as I've understood it, if the cross appeal gets rejected, then you're only left with ground one. So
Yes.
the only breach we're talking about, and I know you put forward a number of alternative bases on which it could
Yes.
be upheld, and obviously we'll think about those. But we've still only got what you might call a limited breach, and I know there's an issue about that language, but let's use that for the moment. The limited breach of the defendant, the respondent, not having a healthcare plan in place by the summer
That's
of
the point.
2024.
That was the point.
That's the breach.
But that was the point I was making, my lady.
Yeah, okay.
That if the cross, try to put it in perhaps more succinctly, if the cross appeal is rejected, this court may not need to consider our notice to affirm.
Got it.
Oh, I see.
Understood.
Oh, yeah,
Yes,
yeah, yeah.
understood.
Yep. Yes, if the
But
cross
that's
appeal
my-
goes, you don't have to labour the point. You don't.
No,
you just
exactly.
say,
Yes.
the cross appeal failed, so the judge got it right, so end of.
Precisely.
Perfectly understand that.
The court may take a different view, so it's entirely a matter of
I mean,
course of the court. But
for my part, the recent notice to affirm, I regarded as sort of a bit of a belt and braces from you, just sort of reiterating all the different points that could have supported
Yes.
the judge's
well, we've
conclusion
answered
as
in
to
the court
ground
below,
one.
and he made no decision about it. But, so I'll bear that in mind when I'm making my submissions on that point. So we come to what was issue one in the High Court, the care plan issue. A few introductory remarks, if I may, on this issue. Care planning is obviously very important for disabled children, particularly so for a child such as A, who has such complex needs and who is at risk of sudden death. The consequence of this is that the care planning itself for such a child has to be especially rigorous, and if considered by the courts will look at it with the most intense scrutiny, given the potential consequences. Now, you will have seen that the duty to produce a care plan derives from Section 42 of the Children and Families Act. We've got that in the authorities bundle. I don't think I need to take the court to it. But that also has to be read together with the statutory guidance, which we have in the bundle at tab 22. It may be helpful just to look at that at this stage. It's the last tab of the authorities bundle. The ladies and the lords. Now this is statutory guidance, as we see from the first page 577 of the bundle, issued jointly by the Department of Education and the Department of Health. And before looking at that, just to say something about...
Sorry, I've lost the page. I was fiddling around trying to...
577, my lady.
Thank you so much. Sorry. Got it.
You see our Special Educational Needs and Disability Code of Practice. Does my lady have?
Sorry, I do, yes.
Yes,
I'm
okay.
there. I'm electronic and they're not, but that's fine.
Yes,
Yeah.
yes. I was just making the point that this is jointly issued by the two departments, and that's consistent with the wider public policy of looking at children with special needs in
The whole child.
which we've seen develop over the last generation or so, and that's now developed or more recently developed into a requirement for a health and social education, health and care plan, what had formerly been a special educational needs and disability plan. Now
this is about an EHC needs assessment.
Yes.
The thing we're talking about is an appendix, isn't it, to the EHC assessment, which is a health and care.
Yes,
plan.
the healthcare bit. But the guidance on the production of that plan is to be found in this document, my lady. We can put it shortly. If we take the court to page 601, this is beneath paragraph 9.69. We see what's to be included in each section of the EHC Education, Health and Care Plan. And obviously it's got education, health and care issues. These headings derive from the 2014 regulations. We don't need to go to them because this is statutory guidance in any event, which has got to be followed unless there's good reason not to do so. So the health bit of this guidance, we find at page 604 of the bundle.
The famous G.
The G, yeah. And the plan must include any health provision reasonably required by the learning difficulties or disabilities which result in the child or young person having special educational needs, which is obviously my client. And you'll see in the first bullet point there that the provision should be detailed and specific and should normally be quantified, for example, in terms of the type of support and who will provide it. Now, as a matter of common sense, the level of detail and specificity will depend on the facts of the individual case. But nevertheless, there's a baseline there that the provision should be detailed and specific. So that's the underlying statutory obligation. In return, as my Lady Justice Whipple mentioned, to the care plan itself, because that's obviously intimately linked with the EHC requirements. We've got that in the supplementary bundle. Page 88. This is the June 23 document.
June, the original, the one that was.
Yes.
Okay. Thank you.
The one that was considered before the judge.
Yep.
Okay. Now it's.
Mr. Wise, you said, I think, that the care plans have to be updated every year. Is that what you told me?
I didn't say that, but they are supposed to be.
Oh. Is there a reference for that? Is that within the guidance, or perhaps? And Mr. Percy may be able to help.
From memory, I think it's.
So I don't want to take you out of your train, but if perhaps Mr. Percy could just flush that out at some stage. I mean, whenever, it can be after. When?
Oh, my junior has an encyclopedic knowledge of these things. 63 of what? 623 of the authority currently. Apparently we've got to pick it up at 9.130 at 622.
Must take place at least annually. Thank you, Mr. Percy.
Yes, and the emphasis on must, of course. So we were looking at the June 23 document, which was the one document that was before the court below that the judge found to be defective. And for present purposes, it's just we just need to note the date and who prepared it. So if we go on to page 107, we see that this was drafted by the nurse manager, Cherie Beckingham of Endeavour Complex Care, who are the agency who had been providing the care for this child, and not signed and dated by a parent, but nevertheless signed by Miss Beckingham on the 13th of June 2023. Now, if we can go back a few pages to the plan, the Education, Health and Care Plan, which, as the judge noted, was dated the 23rd of November 20.
Sorry, which page do you want us to be on, please?
Starts at page 50 of the same body. Sorry, I omitted. But it's the section G, the health provision, that's important, and that's page 81.
Oh, wait, sorry, just you'll have to take this bit by bit. So we're going back to page 50, and that's the Education, Health and Care Plan.
It is, my lady, yes.
And
Our focus is on section G, of course, which is at page 81.
okay, so is this date 15th of August? So this isn't then the Education, Health and Care Plan that went to the first tier tribunal? Because the tribunal was the 11th of July. So it must have been an earlier version. So is this the version that was written in the light of the FTT's?
I'm pretty
This
sure.
is dated 11th of
Postdates
Yes,
the
it is.
tribunal. Yes,
November
well, it
23.
postdates the tribunal.
This is the November 23 EHC plan, isn't it?
Yes.
Sorry, I was confused because weirdly the plan start date was the 15th of August, but the actual date of it is not signed off until the 23rd of November.
That's right, lady.
Okay, so we have a plan. Please don't take us to it unless it's absolutely necessary.
No.
That went to the first tier tribunal.
Yes.
First tier tribunal allowed an appeal against that plan on the 11th of July.
Yes.
We then had presumably a revised plan, that started on the 15th of August, but it wasn't all tidied up and signed off until November.
Yes.
Have I got that right?
Absolutely, my lady. Yes.
But then there's something else that needs to happen, is there, on your case? Because what we're looking at, section G on page 81, isn't enough to fulfil what you see in the guidance, is it?
Precisely.
You say there has to be a separate document prepared by whoever prepares it
Yes.
that sets out in detail who's going to do what.
Or it goes in this document itself.
Okay.
That can go in the document.
Oh, yes.
Yep.
Yes.
So it doesn't have to be a separate document. A freestanding document.
No. And in fact,
Is this not good enough, what we're looking at?
well, just if I can just take your ladyship to the last bullet point.
AMRIC will be provided with a healthcare plan. Yeah? Is that the point?
Yes. So as of November 23, it's recognised that there isn't a healthcare plan.
Yep.
Now, Mr. Justice MacDonald obviously picked up on the disparity between these dates and who's doing what and so forth, and that was his primary finding on that point, i.e. that the plan that was being relied on predated the tribunal and this document that we've just looked at. very important to emphasise why the judge found as he did. So if I can take the court to Mr. Justice MacDonald's judgment, core bundle, page 61. See at paragraph 67, the background that we've just looked at and the dates and so forth. And then he concludes, if we pick it up at the penultimate line of that page in paragraph 69, I'm satisfied that it was not sufficient to fulfil its mandatory duty under section 42.3 of the 2014 Act for the defendant to rely on a care plan that he conceived was outdated and which predated, he places an emphasis on predated, which predated the review process that led to the stipulation for healthcare plan in section G of A's EHC plan dated the 23rd of November 2023. Rather, it was reasonable to expect that the defendant would arrange for a healthcare plan that reflected the outcome of the comprehensive multidisciplinary review process that commenced in June 2023, concluded in the finalised EHC plan in November 2023. So it wasn't just that the document was out of date. That's the way that Miller and Friends seeks to characterise it. It was much more than that. It was that sequence of events and the failure to produce a plan that reflected, as the judge says, the outcome of the comprehensive multidisciplinary review process, etc.
Has the judge made a finding as to the date from which the ICB was in breach of its duty?
No. No, there was no finding of that at all.
Do you have any submission about that?
It must be said in fairness to the judge that that wasn't an issue that we pursued before him. It was an ongoing duty, and our concern was that there wasn't a lawful care plan in place. But it must follow that it was from the logic of what the judge says there at paragraph 69, that it was unlawful from at least November 2023.
Or even August.
Or even August. That's why I say
Mr. Percy's nudging you.
Oh, I'm told that apparently there's a five week grace given. Is this in the code of practice? Apparently there's case law that suggests that 5 weeks is the time that is given to put in place the findings of the tribunal. So the tribunal was on
11th of July.
11th of July, so it would have been.
But the tribunal, help me with this, I thought the tribunal, I'm sure the tribunal found lots of things, but the really important thing was the double care, wasn't it?
Yes,
So
absolutely.
that the tribunal found.
Absolutely.
So that doubled the amount of
Absolutely.
care. You needed 2 at a time for manual handling and so on.
Absolutely.
So that fell to, that had to go into the EHC plan. That was the kind of leading thing. And we do see that happening in November of 2023. You'd say it took too long, but they get to it in November of 2023.
Although it was implemented in August, so probably within near enough the 5 weeks.
Okay. But the point I wanted just to put to you was that doesn't there then become a period after that when this defendant, this respondent, needs then to finalise their healthcare plan? Isn't it a sequential project?
Well, common sense would suggest so. I'm not sure whether there's a statutory
Isn't
ask
that
your-
essentially what the judge is saying? He says
Yes.
it was reasonable to expect
Yes.
that they would do something which reflected the outcome of something that concluded in November.
Yes.
And therefore that they could only be in breach on the judge's finding at some point after November, when they'd,
Or from
Yeah.
November. Or from
Well,
November.
well, they must have some time after
Yes.
November to decide exactly what they're going to do as a result of what happens in November.
Yes.
Maybe 5 weeks by analogy, but that sort of time frame.
The reason that wasn't an issue that came to the surface, my lord, is because we were concerned primarily as to what was going on in July 2024 and afterwards. So it really made little or no difference in practical terms whether the unlawfulness started in August, September, November or October 2023.
Well, I can understand that.
But what we know now is that the November plan you took us to it, the final line, there will now be a care plan.
Yes.
And picking up Lord Justice Males's point, there then had to be a period of grace after
Yes,
that. So
yes.
if we were looking at when the breach, ground one was at
Yes.
if we're looking at when the breach started and one tried to put a date on it, it would be a few weeks after that.
Thereabouts, certainly.
Yep, thank you.
But nothing practical hangs on it for this case because the restitution claim comes starts.
Yeah, but you haven't.
only-
But
only
we have to
starts
look at them separately as well as together.
Oh,
don't we?
absolutely. Yeah.
All right.
My lady. The point that we were emphasising there was that the logic of the judge findings. It wasn't just that it was simply out of date. It was out of date, and that they hadn't done X, Y, and Z
Yes.
when they could be reasonably expected to do so. Now the respondent seeks to cross appeal for two reasons in their notice of appeal. Appellant's notice. Firstly, they say that the judge was wrong to find that the June care plan was out of date when there was a new care plan progressing. Well, the short answer to that is that the judge knew full well that there was a new care plan progressing. And indeed, if we still have page 61 open, the judgment, we can see reference there to Maloney Friends submissions that there was repeated requests for an updated plan from indeed the claimant to deliver the plan. So it was obviously being requested, and the judge was well aware that there had been work taking place on that. But dealing with it very shortly, it doesn't make any difference. There was a statutory obligation to produce a care plan. It's a mandatory duty, as the judge made absolutely clear. There's case law on it. I think it was the Hampshire case that the judge referred to. And they simply hadn't complied with it. The fact that there was a new care plan progressing is, or in progress, is neither here nor there. And the second ground of appeal is that the decision that the care plan was out of date, well, it's more than it was out of date. It was said, is said by the respondents to be unfair due to the non-disclosure of the August 24 document. But we say that that's flawed for a number of reasons, and you've seen the points that we make in our skeleton argument on that. And the genesis of the later document and who had it and when it was available to the integrated care board. We see from the witness statement of Rebecca Carrier, and just state the point that that's in a further supplementary bundle, page 114. The solicitor is very concerned, as we see from paragraph 2, that about the suggestion that the that this document had been knowingly withheld. What she describes a very serious suggestion, which she says is simply not true. So,
Well, she says she thought it was a draft and not relevant.
yeah, absolutely, absolutely. And also, she goes on to say that they understood that they had. She understood that they had it anyway through the Whittington Health team. Who were
Yeah, but
working with,
that wouldn't be a reason not to put something in the bundle.
No.
If she
No,
thought it was relevant.
But there's the prior point that my lord makes initially that
She didn't think it was relevant.
that she didn't think it was relevant.
Did she not, when she was listening to this, I don't know if she was in court, but the whole case put forward by the defendant was that they hadn't got anything at all from Enviva and that they'd chased and hadn't got anything, as I understand it. Was it not something that you think, well...
They didn't put it quite like that. The way it was put, they were chasing it. They were still waiting for the care plan to be produced.
But,
Yeah.
It hadn't been.
but your solicitors knew it had been produced.
Yeah.
Well, no, it hadn't. I mean,
The draft had.
Well, it wasn't. Well,
It's a
to be
draft.
fair, it's not even a draft. A draft anticipates that it's at a fairly late stage and is out for consultation or for comments or what have you. But if we look at the document, we see that.
Well, what you can see in it, I've looked at it quite carefully, and you can see that it is different from the one that went before. The
Oh, yes.
format's the same, but the content is different. And it does seem, at least, to meet this child's healthcare needs in light of the new EHC plan that was put in place in November of 23. Seems to be addressed to that.
But on its face, it's a draft, and it says repeatedly there's awaited updates, awaited update on the medical report, for example, which is
But why
absolutely
wasn't it
crucial.
just, because the judge was proceeding on the footing that there was nothing, because that was what the defendants, as I understand it, thought the position was. They just hadn't got anything back from Enviva, and that wasn't correct, in fact. They had got something back.
Well-
You could have had the debate about whether it was enough or not
Yes.
enough, but that Enviva had produced this document seems quite material.
I mean, it goes even further because in Ms. Collins' second statement, she says Enviva were repeatedly requested to update their June 2023 healthcare plan and send it to the ICB, but
Yes.
they have not done so. And then she speculates it may be that Enviva have updated AMRIC's healthcare plan, and if so, we would hope that Enviva would also share AMRIC's updated care plan with the new provider.
Yes.
So it's perfectly clear that so far as the ICB were concerned, they hadn't had anything, and they were wondering whether there was anything out there.
But that is in conflict with what Mr. Burney says in his statement, where he says that they had got it and he just hadn't opened the emails.
But that might be true. Both things might be true.
Well, that's true.
It may be that there's no great mystery here, that it had been sent to the ICB and it was sitting in a digital vault somewhere. I mean, these things do happen.
Of course they did. Of course they did.
But I suppose just the question is, if that, if you're listening to this and you know what the defendant's position is because it's been articulated in witness statements and it's being articulated orally, does there not come a point when you think maybe there's a misunderstanding here? Maybe they don't know that there is a document that was sent in draft, and you should say so.
First of all, it must be appreciated that this was all happening very, very close to the hearing of the matter.
Well, that cuts both ways, Mr. Wise.
It does, but it must be appreciated.
Yes.
I mean, this was in September 2020.
Yeah, but that's where the duty of candour is at its sharpest,
Oh,
because things do blow up.
Well, that's absolutely right. But it wasn't. It didn't even pretend to be a care plan. The IC.
Well, let's just look at
the ICB. Well, before we do that, my lady. But the
I'm
ICB.
saying it doesn't even pretend to be a care plan. Let's look at the title for a start, shall we? I think Mr. Percy's getting desperate to pass something to you, Mr.
Bear
Wise.
with me one moment. Yes. Yeah.
So let's just have it. I mean, we want to hear your submissions on it, and particularly picking up what my Lady Justice Whipple was asking you about. But I myself would like the document in front of me.
Yes, absolutely. We've got it's page 88.
Of the further supplementary.
Yes.
Yeah. Thank you. Care plan.
But that's the pro forma. that hasn't been put.
I understand that.
With any to describe it. But the point my junior makes behind me, and I was coming to anyway, is that at this juncture, Enviva weren't working for the ICB. It was nothing to do with the Enviva were being instructed privately by my clients.
Yes, the draft, we'll get to it, is dated June 2024, and then it's signed off, or there's a bit more on the 2nd of August 2024, so it straddles the period before and after Enviva stopped working. But it goes to the point that was raised by the defendant saying we thought this was an obligation that Enviva was meant to be doing, but we hadn't received anything from them. It's just that.
Yeah.
And it was known in the court at the time that there was a document. It was a draft, you might say, but the judge wasn't given that piece of information.
But it was still work in progress. It wasn't a care plan that the ICB purported to rely on. Yes. Okay.
Mr. Wise, also, nobody's suggesting that your instructing solicitor or counsel dealing with the case at that stage was being deliberately improper or hiding documents. But mistakes happen, which have consequences. So it may be quite right that a judgment call was made, which was a mistake, which wasn't picked up during the trial. And what we have to think about is what impact that did or did not, or may not have had on the outcome and on these applications.
Yes. Well, I'm going to come to that in a moment. But your ladyship wanted to look at the plan itself first.
Well, you're saying it's not even a care plan, and I'm afraid I was struggling with that as a submission.
Well,
I mean, I accept, of course, it's a draft, but it's a very, very detailed document.
Well, it's a descriptive document. We say it's merely a descriptive document because it says repeatedly. I mean, if we can go just picking it at random, page 99 of the bundle, with towards the top of the page in bold, this is currently being updated regarding types of seizures and triggers. Well, that's obviously a key factor. So that's work in progress. And if we go further down that page, toward opposite the bottom hole punch, we see in brackets, currently waiting for his team to support this and to put together a well and unwell plan to support Amric at home. If we go over the page, over to page 109, on routines, is currently being updated according to school, an updated routine to be added when finalised. If the previous page, 108, towards the bottom of the page, the issue of seizures and moving handling requirements has now been escalated to his multidisciplinary team, is currently under review, so a care plan can be put in place as to best support him. But these are absolutely crucial issues for any care plan, of course. And then if we go to the appendices at page 110, 13, medical report, awaiting up to date. So all the crucial issues as far as the care of this child are concerned are still outstanding. I can't
see a
possibly
list of reports of which only one is awaited.
Well, it is the medical report, my lady. It's obviously extremely important. All these others aren't don't necessarily give rise to care needs.
What, a seizure management plan?
Well, not all of them. Not all of them do, is what I said. But the medical report is obviously, given the condition and the vulnerability of this child, absolutely crucial. So is the manual, the manual handling report, absolutely crucial. And there's other instances where reports are awaited. Page 102, meal, mat and support plan to be updated once completed.
It was difficult to think that by losing my bearings on this, but by August of 2024, it was going to be possible for the IDT to have this concluded, certainly through Enviva, because the relationship had broken down. The IDT had nothing to do with
Precisely.
it anymore. So, yeah, but I mean, actually, by this stage, the IDT were having nothing to do with the child's care. So there was a complete breakdown by this stage. So how was the IDT to comply with its responsibility?
How were they to comply?
Yeah, I mean, how were they to know what? They couldn't get in to see the child.
Well, they had a mandatory duty to produce a care plan.
Well, that's why they issued care proceedings, weren't they?
But it wasn't. But there was all sorts of background reasons for that, and as you appreciate, we don't need to, I think, go into that at the moment. But there was, my lady, Lady Whipple said that they weren't allowing the ICB to see the child. I don't think there's any evidence of that. There's no obstruction on behalf of mother.
The nursing, whatever. I can't
No,
remember.
but there was one. The agency people.
They arrived on the 10th and the 11th.
Yes.
And then no, not after that.
But that was because they arrived without any knowledge of the child's needs. They didn't even know the child's name. No idea of what the needs of the child were. And not surprisingly, given the vulnerability of the child, mother wasn't prepared to have this extremely vulnerable child left in their care. So that prompted her then, or her and her husband then, to procure the care for themselves. And it was because there wasn't a proper care plan. A proper care plan should be able to be picked up by any care agency and put into operation. It should tell the agency or the.
I don't think anyone is suggesting for a minute that this was a finalised care plan.
No.
I think for my part, what I'm struggling with is your submission that this was not even a draft care plan; it was a nothing. And I'm afraid I've struggled with that.
Well, we've always described it. We've always described it as a draft plan.
Well, your oral submissions were it wasn't even a proper draft.
It's a very poor. It's work in progress. Obviously,
You said 5 minutes ago it was merely a descriptive document.
Yes.
Well, it's that as well. But that's how we characterise the earlier so-called purported care plan as well. It's a descriptive document rather than a detailed plan of action that sets out what care is going to be provided for this child. But the real nub of the point is well, what difference would it have made anyway? That's picking up on the Ladden Marshall criteria.
Well, we're looking
now,
at
we've got
these.
the due diligence.
You don't need to go through Ladden Marshall. We're looking at these in DevNASA in any event.
Well,
I work on the basis. We're hearing all your submissions against the backdrop of the evidence you wish to adduce.
But it is important, nevertheless. I take the point you make about due diligence and mistakes happen and so on, and of course they do. That's what happens in these things. Unfortunately, happen in the real world. But the real question is, would it have made any difference? Would the judge, for the appeal court, would the judge at first instance, would it have had a material effect on his judgment? That's the nub of the issue in our submission. Now, the defendant puts forward a number of points as to why they say it would have made a difference. And the first point they make, this is in their skeleton argument, if I can just pick that up. It's paragraph 88 of page 21 of the respondent's skeleton argument. And you'll see there A, B, C, D, five points are made by the on behalf of the Integrated Care Board. The first point is the respondent could have considered accepting the August 24 draft care plan as a new care plan, and subsequently argued that ground 1 was academic. But it couldn't possibly, in our submission, have been described as a final care plan. It doesn't even...
Sorry, I'm lost where you are. It's
So,
wonderful.
respondent skeleton argument, my
Yeah.
lady. At page 21,
The internal numbering.
yes.
No.
I don't know if you have it in a
Yes.
bundle, I've got it separately.
Paragraph 88 of the skeleton argument. Thank you. Oh, I'm in the wrong one. It's not the one. I flagged it the wrong. Paragraph 88. Keep going. I'll get there. Yep. Thanks.
Well, yes, so little a, you just say, well, they couldn't possibly have accepted it because it was only a draft.
Yes, and frankly, we would say that that's an absurd point.
I don't think you need to go any further with that. You're clear what your point
Second
is on
point,
that. Second
they
point.
could have argued that permission should not have been given on the ground that the continuing care process was in fact producing a new document, and delay alone is not unlawful.
Yep.
Well, again,
What do you say about that?
everybody knew that a new process was in place, and indeed the judge knew that. He was told that.
But he thought nothing had happened at all, and in fact what was happened is there was a pretty well worked up draft available, which he wasn't shown.
No, but he knew there was work going on behind the scenes. There was a work in progress on a document.
He knew that the Integrated Care Board had been chasing Enviva
Yes,
for one.
yes.
As I read his judgment, that's all he knew.
I thought he said in his judgment somewhere that he knew that. I'll come back to that, Milady. I thought he'd gone further than that. But even so, returning to the point that's made against me, the fact that there was a new document being produced doesn't absolve the Integrated Care Board of its mandatory duty to have a care plan in place. Thirdly, it said that the court could have compared the former care plan and the new care plan to decide if the material differences to test the breaches asserted by the claimant in ground 1. But that wasn't the point on which the material differences wouldn't have affected in any way the finding that the judge made, i.e. that there hadn't been an updated care plan in the light of the multidisciplinary meetings, etc. And that applies equally to the August 24 document as it did to the earlier document, because we've just identified the multidisciplinary meeting input hadn't been put into that document. The fourth point, the respondent's argument below that seeking to update the healthcare plan was sufficient to discharge its duty to arrange the healthcare plan. But it's impossible to understand why that submission, which was rejected by the judge, would have been altered. The rejection of that submission by the judge would have been altered by the production of this document. Seeking to update the plan wouldn't affect the lawfulness and failings that he identified. And then the court finally said that the respondent would have argued that no mandatory order was required on the basis that a new plan was in train. Now, the mandatory order that the judge made was that a care plan be produced by, I think it was the 27th of November. The care plan was indeed produced on the 27th of November. No need to go into the rights and wrongs of that at this stage. It wasn't an update of the Enviva plan. They had to start it. They started again. So it wouldn't have made a jot of difference to the. It's impossible to see why the production of this further draft, if we'll call it the August document, why the production of this August document would have had any impact on the mandatory order that the judge made. They would still have to been required to produce a final document in compliance with the law. And the fact that it wasn't a question of dotting the I's and crossing the T's of a pre-existing document shows that the production of this document wouldn't have made any practical difference at all. So it's very difficult to see that there's any of these points would have made any difference to the judge below. And you'll see in the skeleton argument we make 4 points, and I can deal with it. This is our skeleton argument, paragraphs 40 to 51. I'll deal with them very shortly because the court's already read these. But the first point we make, paragraph 41 of a skeleton, is a copy of the draft care plan was with the respondent before the hearing in any event. The second point was that the draft care plan was with Whittington Health, and it's absolutely clear from the evidence that the Whittington Health was working with the Integrated Care Board, and the work was, I think, was described as intertwined in determining the needs of children who require continuing health care. Now, I don't know if the courts pick this up, but what in fact happens in this Integrated Care Board essentially subcontract the production of or the decision making, or the information that contributes to the decision making as to whether there's eligibility for continuing health care, because that in itself is an issue in itself. It's a threshold and a complex guidance which determines whether a person in the community, obviously continuing healthcare means outside of hospital in the community, determines whether a person is eligible for that continuing healthcare, and it is paid for by the health service rather than by social services. And obviously that has very practical consequences for families, because families have to pay for social care subject to thresholds and so forth, whereas healthcare is provided for free at the point of service. But perhaps the most profound point is that the quality of healthcare is different than the quality of social care, because healthcare involves specialist staff and with a higher degree of skill and expertise than social care staff. And I don't say that to denigrate social care staff in any way, but that social care wouldn't provide nursing care, for example. So Whittington Health had got this document. Whittington Health were working with the ICB in the decision making as to whether there's a obligation under the ICB to provide continuing health care. And we can see that there was regular communication between the ICB and Whittington Health. We get that from the emails that are exhibited to Miss Carrier's witness statement. I don't know if the courts had the opportunity to look at those, but we see how the ICB and Whittington Health are in constant communication about this.
I'm not sure where this point is going.
Well,
because
they're all working together, basically.
Yeah, and then it was passed on, we know, and there's an acceptance that it was passed on.
Yes.
So I'm not sure why we're examining the nexus between Whittington Health and the ICB for the purposes of your arguments.
Because the implication from the ICB is that they didn't have this document.
Well, they've conceded ages ago that they've had the document. They just haven't read it.
Yes.
So why are we examining the nexus between Whittington Health and the IC?
Well, if that's the simple point that they hadn't read it, then really it doesn't behove them
I don't want to, you know,
to say that the document wasn't available.
I didn't think that's what they were saying. I thought they were saying. Just let me turn up where I thought I was reading this. Page 113 for the skeleton argument. I mean, sorry, for the supplementary bundle, page 113. Miss Alva, who's part of the Integrated Care Board, explains how was to be shared as a working document. It was all sent by Whittington on the 13th of September. The link was downloaded. I did not review the documents at the time.
Yes.
Now,
Accompanying paragraph 8, no document was ever sent to me, she says.
yeah. So she got.
No.
So I think, so my reading, which Mr. Lawson will undoubtedly correct me if I'm wrong, is that what we were being told in this fresh evidence was that the August document, draft care plan, wasn't sent directly to Ms. Alva, but they received a bundle of documents from Whittington, of which one, no doubt, deeply embedded attachment.
Well, we get that from
was the care plan, and she frankly says, I didn't look at the documents at the time, and she first became aware of it in November by Mr. Burney, the clinical lead. So I'm not seeing any suggestion on the part of the Integrated Care Board that they didn't actually have the document. It seems to me actually probably by the 13th of September. So could you please tell me why we're examining the nexus between Whittington and ICP?
Because one has to understand what this document was produced for and why it was sent to Whittington. It was produced for the purposes of determining whether there was a continuing healthcare need. It wasn't being produced.
But there was no suggestion it wasn't. It was the proposed care plan in the light of the
updated EHC in November 23.
No, it was the document that was sent to Whittington Health to inform their decision as to whether there was any continuing healthcare need.
Well, how does that tie in with your lay client having agreed to the draft care plan being the basis of a future final care plan subject to further negotiation?
No, she agreed to it. She agreed to it being sent to Whittington Health for the purposes of their determination of whether there was a continuing.
That's not the evidence. Mr. Burney says he got a message that there was an August 2024 care plan from A's legal team. That's the people who sit beside you. First time it was paragraph 19 on page 84. So he tried to chase it down. He then, paragraph 21, looked in A's folder on the shared drive and located a PDF document entitled Care. Well, we've seen that care plan draft. So everybody was approaching this on the basis it was a draft care plan.
Yeah, but for what purpose?
Well,
That's is the question we ask. If you just bear with me one moment, my lady. If we look at, just bear with me one moment. I'm just looking for a particular document. Just bear with me 1 second.
Had it ever been suggested by anyone for any purposes that this child did have a continuing entitlement?
Oh yes, it is. Yes, absolutely.
Right.
Absolutely.
Okay.
In fact, Whittington have said in their provisional review, based on these documents, that he doesn't have
What, currently?
Yes, that's the current position.
But at the time, this
But it's not a final decision.
But I thought a new care plan was going to be implemented any minute now.
Yes. And we're awaiting
against the backdrop that he wasn't entitled to anything.
against the backdrop that there is an initial decision which now goes to panel that he's not going to be entitled to continuing health care. And that's what this document was all about. Just bear with me one moment, a second. So I found the document that I'm looking for now. Yes, it's in the witness statement of the solicitor, Miss Carrier. Can I take the court to page 114 of the, I think it's the further supplementary bundle.
Sorry, first supplementary.
The second
Further
one,
supplementary.
I think the further
Page
supplementary.
11.
114.
Thank you. It's Miss Carrier's statement.
Yes. She says at paragraph 3, the last sentence, page 116, for the reasons set out below, the August 2024 draft care plan was not, and in my view isn't, not relevant to the matters before the administrative court. And she then goes on to explain that she'd received the draft care plan on the 12th of August, and it's described as the latest draft version. It cannot be finalised without updating medical evidence. Nurse mind, you can't make things up. She needs to have clinical reports. That was the description of mother when sending it to the solicitors on the 12th of August.
She says, as the draft care plan was just that, a draft, thereby I didn't consider it to be relevant. That's what I understood the case to be.
She then goes on at paragraph 5 to say, it may assist if I explain how the document came to the attention of the respondent solicitor, that's the ICB's solicitor.
But we've read all of this.
And she says that it was her that brought it to their attention.
When they got to the point of actually negotiating the care plan after the hearing.
Yes.
She said,
Yes.
by the way, you might be interested to see this.
Yes. But the point is that it had been forwarded from Miss Marotti at the Whittington Health Care for the purpose of the continuing healthcare review. So paragraph 10, page 119, I understand that the respondent had the August 2024 draft plan has been provided to Miss Marotti. The court will be aware Miss Marotti is employed by Whittington Children's Continuing Care Team, etc. I understood the delivery of the draft was all intents and purposes delivered to the respondent.
Yeah.
And then paragraph 11 over the page. Invite the court to read the final 8 lines, 6 lines of that paragraph.
Yes.
And then says how mother dealt with the document at paragraph 13.
So is this saying that because by this stage the parents were paying Enviva, that the product of Enviva's work in August 2024 was for the parents and
Yes.
wasn't something that
Yeah,
anybody
nothing
else
to do with the
could buy?
ICB. Nothing
Even
to
though
do.
Enviva had drafted this, I think the first date on it is the 2nd of June.
That was when it was uploaded onto the system,
Okay.
obviously. But
Okay.
but by
But
that
it was obviously in
time,
existence.
well,
Then, wasn't it?
a document was in existence. How much of the template had been filled in, we just don't know. And, excuse me. Oh, I'm told behind me that there wasn't a document in existence in June. I don't know where your ladyship
I got that from the document itself, the August
Yes.
2024
Can we just
care
have a
plan,
look?
the signature page, on page 111. It says the first draft's reviewed on the 20th of June. The second draft is then dated the 2nd of August 2024.
Bear with me one.
That's page 111.
Now, Mr. Wise, I'm actually also conscious you've only got 55
Yes,
minutes now. For
I
your
am, but this is
restitution.
obviously a point that is true. Can I just come back to my, Lady Justice Whipple's point? Sorry about the June date.
Yes.
I haven't got the document in front of me when you were making the submission. What?
It's page 111, internal 24, of the further supplementary bundle.
Yes, yeah. There's that date there. Yeah. But that doesn't take away from the fact that by the time this document was issued, we don't know what was written when. But certainly as of August 2024, Enviva were working contractually for my clients.
So this was a document that was commissioned by the ICP. They chased and chased and chased. There was a first draft before they finished working for the parents, a second draft after, and you're saying it's not anything to do with ICP. But I don't think you're saying that's why it wasn't disclosed.
Well,
It's something which, on the judge's findings, should have been completed
Exactly.
during the time when Enviva were employed by the ICB.
well, we've got no evidence from the ICB. We just don't know what the arrangements were between the ICB and Enviva at that time and what was being done. Just bear with me one moment. I've just asked to...
It's just not right, is it, to say it wasn't prepared at the request of the respondent? Because it was prepared at the request of the respondent, wasn't it? It may not have been. I mean, it may be by the time you get to August, things have got more complicated. But the initiation of this was at the respondent's request, wasn't it? Isn't that what we see from the
Yeah,
evidence?
but the ongoing work was after Enviva had been sacked. They'd been sacked by the respondent by this time. They were sacked on the 9th of July. We've no idea what they'd done up until the 9th of July.
Well, we do, because we know there was a first draft that was reviewed on whatever date. Well, everyone's shaking their heads behind you, but we're looking at a document which is signed by the author of a date in June. So if it's all saying that didn't exist, you're going to have to, not now because you need to move on to restitution, but someone's going to have to tell us after the short adjournment why, effectively, that's an untrue signature. That's not an honest signature.
Well, we're not. Nobody's suggesting it's not an honest signature.
Well, you must be, because it says signed and print Cherie Beckingham, date first draft reviews 20th of June 2024, and there's her signature.
Yes, yes.
Now, if it's saying, and everyone behind you is shaking their heads vociferously, and I respect that, they're very immersed in this case.
Yes.
Are saying that there was no such thing, that didn't happen.
Well, we haven't
Now,
seen any document. We've no idea.
That's not the point.
Anyway, the point that the respondents make is that this document should have been before the High Court. This document is dated August. It was produced by Enviva, who were at that time
Well, we have your arguments, and you've very carefully and helpfully been through the 5 critical points that are raised in the cross appeal, and that's most helpful, certainly from my part.
Yes. Sorry, I hadn't anticipated that would have taken so long, but
Well, I think we have your submissions in relation to the care plan.
well, that leads on then to our notice of notice to affirm, and
I thought you weren't going to go through those.
well, only if the court isn't with us on with respect to the cross appeal.
Well, you've got till lunchtime. So if you want to go through those in detail, that's how you use your time is, of course, a matter for you, Mr. Wise.
Yes. I did say I hope to be finished for lunchtime.
Well, I dare say Mr. Lawson will be gracious to perhaps 2:30.
Yes. if the court isn't with us on that,
Well, take us to the,
on
where,
that.
just remind us where we find in the bundle your notice of affirmation.
Further
Well,
supple-
you deal with it in your skeleton argument.
yes, well, the notice of affirmation is in the further supplementary bundle at page 29.
And we find it in your skeleton argument, so I reread it this morning, at paragraph 91 onwards.
Yes. And the court has the point. Can I, I'm not going to read the skeleton argument out, but if I could just develop the point for one moment. The judge didn't find it was necessary to decide this point, obviously, because he decided on the prior point, and we get that from paragraph 51 of his the judge's judgment. We've looked at the code of practice. We saw the special educational needs codes of practice that requires care plans to be detailed and specific, and normally be quantified in terms of, for example, in terms of type and support and who will provide it. And what we did before the court below, and we repeat it in this court, is rely on analogous children's care planning cases, which look at care planning for children in a range of circumstances where the children are vulnerable and they require support. There is no case law in this particular context with respect to independent integrated care boards. But we say that the analogous these children's care planning cases are analogous because they are with respect to similar legal requirements on public bodies who owe duties towards children. And there's a common thread that runs through all these cases, which is that there needs to be a rigorous assessment, a plan setting out, determining what the needs of the child are. Firstly, there needs to be an assessment of the child, usually a multidisciplinary assessment to determine the needs of the child. Secondly, there needs to be a plan setting out how those needs are to be met by whom and when. And thirdly, the provision setting out how the child's needs are to be met has to be provided. So it's those three stages, and we see that across the piece in cases concerning vulnerable children. We say that those principles apply equally to healthcare for vulnerable children provided by integrated care boards as they do with, for example, local authorities looking after children at risk or in need. Now, we've got in the papers 3 cases. They're all first instance cases. They haven't gone to this court because, by definition, they're all cases that are very, very fact specific. But it is instructive to consider how the various courts, the various judges have considered it. The first case is an old case by the judgment of Mr. Justice Richards, as he then was, the AB and Nottingham City Council case, which we've got at tab 9 of the authorities bundle. This was a case of a child in need, as defined by section 17 of the Children Act. There was also an issue as to whether he was a child at risk as per section 47 of the Children Act. The report's at page 206 of the authorities bundle. In this case, the planning and provision was guided by the Children Act guidance, working together to safeguard children. And we see at paragraph 20 what the requirements of that guidance are, which highlights the detail required for an assessment, process of carrying out an assessment, etc. You see that between letters E and F on page 212. Then if we go on a few pages to page 217, picking it up at paragraph 41, Mr. Justice Richards describes the tenor of the framework document and what's required by it. Against the letter 8, it's important, moreover, to be clear about the three-stage process: identification, needs, production of a care plan, and provision of identified services. Paragraph 42, I cannot find in the documentation anything approaching an assessment capable of meeting these requirements. The child protection plan prepared and reviewed from December 1999 onwards was thin and left a great deal unresolved by the time the child was taken off the child protection register.
Mr. Wise, presumably this was what purported to be, and I advisedly say purported to be a final care plan.
Pardon?
In this case,
yes, absolutely.
Yeah, whereas what we're dealing with is what, on any view, was purported to be a draft care
plan. No, the document that was before the High Court, the earlier document, the June 23 document,
was a final document, obviously.
Yes.
Be it rather elderly.
Sorry, perhaps my mistake not making it clear. This was the alternative argument in respect of the June 2023 document that was put before the judge below, and we say that his decision should be affirmed for that reason. But in the event that it's considered that the later document is a final document, then exactly the same criticisms.
I don't think anyone suggested that.
Well, in the event that, well, it is suggested because the respondents say in their skeleton argument, one of the submissions that they could have
adopted it, I understand.
They could have said it was a final care plan. Returning to Mr. Justice Richards' judgment, if I may, page 218, paragraph 43, what he says there, nor do I consider that the January 2001 assessment was adequate in terms of the guidance. It was essentially a descriptive document rather than assessment, and in any event, sufficient detail was still lacking, both as regards the assessment itself and as regards the care plan and service provision. There was no clear identification of needs or what was to be done about them, by whom and by when. And that's the phrase that we alight on: what was to be done about them, by whom and by when. The court's seen the document, and we say that it doesn't do that. I'm going to turn over the page to the next tab. This is a judgment behind tab 10, starting at page 221, of Mr. Justice Mumby, as he then was. This is a Nottingham case where he picks up a similar theme, which is a 2008 case, a year or two later. If I can take the court to paragraph 34, he there refers to an earlier judgment of himself, the Cathilly case, and that was concerning pathway planning for children leaving care, which had its own regulation, so it's not guidance, this is done under regulation. But he says, very pertinently, we say in the second paragraph in the indent on citation from the Cathilly case, a care plan is more than a statement of strategic objectives, although too often these are expressed in the most vacuous terms. A care plan is, or ought to be, a detailed operational plan. Just how detailed will depend upon the circumstances of the particular case. So, Mr. Justice Mumby, as he then was, describes a care plan as a detailed operational plan. And then the third case, and we've only selected these three cases out of a number of cases, is the Hillingdon case, which we've got behind tab 12, which is a judgment of Mr. Justice Nicklin of 2017, where he relies in this case on the working together guidance, which my lady will be aware is the primary guidance for safeguarding children. He sets out the relevant provision of the working together guidance at page 305, and you'll see the indented paragraph 53 just below the bottom hole punch. The plan should set out what services are to be delivered and what actions are to be undertaken by whom and for what purpose. Bearing in mind we're looking at this for the purposes of seeing whether the care plan, purported care plan in this case, meets these requirements. And we see at paragraph 54, on the facts of that case, the child had two identified health and safety risks. This is page 311, paragraph 54. towards the bottom of the page, identified 2 health and safety risks: the risk of drowning in the bath arising from having a fit while in the bath, and the risk of being knocked over by on the busy road outside the house. Risk being greatest when transferred to the car. So it's a risk to the life of the child. And we see at paragraph 53, we see at paragraph 59 in the judge's decision why he found the assessment process in that case was flawed. And in doing so, he relied on the Caphilly case, as we see from paragraph 60. At its heart, the section 17 assessment requires an analysis of what, if anything, requires to be done, when and by whom. So we then ask whether that stringent requirement is complied with in the present case. The court's seen the June 23 care plan against the background of the guidance, and of course the section 17 cases that we've seen there are predicated on guidance, not a statutory provision. That a care plan, to be fit for purpose, has to say who does what, where and when to meet the needs of a vulnerable or disabled child. And this document simply doesn't do that. It doesn't say who does what, where and when. It doesn't stipulate what... just bear with me one moment. It doesn't set out how many hours of care the child is supposed to have each day. But although it says that he has seizures, child has seizures and requires constant supervision, doesn't say whether this requires 24/7 nursing care. It doesn't set out whether the carers have to be nurses or non-nurse carers, a crucial issue where the health needs are so complex and so potentially profound as they are, and actually profound as they are in this case. Doesn't set out what qualifications and experience carers are to have, whether qualified nurses or not. And on that point, carers themselves, of course, have different levels of qualification and experience. There are carers who provide social care, who provide daily functions for many people that don't require any particular experience or care. Carers for children or indeed adults that have got particular needs obviously need to have the necessary skills and experience. Doesn't set out the qualifications, experience the carers or the nurses have to have. Obviously the nurses have to be of a particular quality as well. Doesn't set out what the daily tasks the carers are required to do, or if it does so, puts them in a very skeletal form. Doesn't set out how the medication is to be given, and doesn't set out a contingency plan in the event that the caring arrangements fail. So for all those reasons, we say that this plan fails comprehensively to meet the strictures of the requirement to say who does what, where and when to meet the needs of this disabled person. Mother says in a second witness statement that the court hasn't, I won't take you to it because of time, that the ICB have never identified the experience and skill set that is required to safely meet the child's needs. And you will see that underlying the dispute that took place when the care was withdrawn and all the difficulties that arose at that time was the quality of the care. That was the real issue that concerned the mother. Without the required quality and quantity of care, the child's life was at risk in the view of the mother. So we see this isn't an academic exercise. It's not a case of tick boxing or anything like that. This is has a very real impact on the care of a child as vulnerable as this. And I take the court back to the point I made, I think, at the outset, which was that when we're considering public the obligations of public bodies to disabled people such as this, the obligations on the public body are heightened in relation to in direct relation to the potential consequences of the support or not support that they are given. So in other words, there's a greater degree, a greater obligation, a higher obligation, where a child's life's at risk than it is when a child's life isn't at risk. And by extension to that, the obligation on this court and the court below is more pronounced where the consequences are more profound. There's a direct relationship between the profundity of the potential consequences and the intensity of review. That's a point that the Supreme Court made in the KM case. I think the court below was stating to that. It was Lord Wilson in that case. We don't have the case in the bundle. Now the defendant says that the cases that we've just taken the court to can be distinguished on the basis that they have different statutory backgrounds and are subject to different guidance. And it's obviously correct that they've got different statutory backgrounds and are subject to different guidance. Of that, there's no question. But that's not the point. The point is the underlying fundamental point as to what a lawful care plan for a disabled child requires, whether it's a child with mental health difficulties, a child leaving care, or a child with profound health needs. As we said, there's a common theme that runs through all these cases, and indeed the guidance itself dictates that this degree of specificity is required in order to be an adequate and lawful care plan. So the point that's made, although predicated on a correct proposition that there's a different statutory background, doesn't make any difference. It doesn't matter whether it's a Section 17 child in need under Section 17, as Mr. Justice Richards, as he then was looking at, or whether it's a child being looked after, having care provided by an integrated care board, such as my client. And the alternative argument raised by on behalf of the Integrated Care Board is that the plan itself is in fact sufficiently detailed. Well, it isn't.
Well, we've heard your submissions about that.
That's the reason we've already said. So for all those reasons, we would invite the court to uphold Mr. Justice MacDonald's decision on that ground, as advanced before him as well. Move then to consider restitution. Which is a very different area, but consequential to the submissions that we've just made. The court will be aware of the 4 signposts to be considered when determining a claim for restitution or unjust enrichment. I'm going to use the words restitution and unjust enrichment interchangeably. So it can be seen as restitution or unjust enrichment, but the cases use the terms interchangeably. The critical issue here is the second of those signposts, and you will have seen these referred to in the case law, namely whether there was unjust enrichment at the expense of the appellant, given that the majority of his care had been paid for by his parents. Mr. Justice MacDonald found against us on this issue. Although curiously, and my learned friend brings this out in the skeleton argument, it was said that there was no argument on this point. I'm afraid I have to differ with what the judge said at the remedies hearing. There was argument on the case, and the judge was specifically taken to the CP case, which we'll come to in a moment, on the point about whether there's whether restitution can be applicable where there's been third-party involvement, such as occurred in the present case. But that is perhaps by the by. You will have seen that in the court below, and again in this court, we rely very heavily on the CP case. In the court below, we relied principally on the judgment of this court, and it was only afterwards that we looked in more detail at the judgment of the court below. And so can I take the court to the judgment of the court below, because it's very instructive to inform us as to what was being decided by the Court of Appeal in that case. It's behind tab 17 in the authorities book.
Thank you.
The court will be aware of this case from its pre-reading, so I'm not going to go through the background to this case. In any event, we've got it.
I think you'll find that we've all concentrated on it, given your helpful focus on it in your skeleton argument.
I'm much obliged, my lady. You will see, therefore, that in the head note, and we'll come to the detail of this in a moment, this is page 419, that any claim for monetary payment for public law breaches would have to be based on the principle of unjust enrichment, but the authorities which are found to have erred in the way they administer funds under statutory duties do not readily fall into the category of unfair advantage, etc. So that's what the deputy judge below found. If we can just look at the claimant's arguments in the case, we've got that starting at page 435. You'll see the heading respective submissions, under which we have the claimant's arguments, and you'll see in paragraph 59, insofar as it represents the culmination of the argument which is advanced, I summarise it as follows, and it's D halfway through that paragraph that's important. In order for the payment of the fix and kicks fee, care, support and transport going forward, declaration of breach of A2P1, we don't need to deal with that, and F, the adjournment of any question of compensation and restitution resulting from the court's determination. So if we can go over a couple of pages to see how it was, the submission was advanced, bearing in mind this was the claimant's submissions in that case, i.e. on behalf of CP.
So what paragraph are we on?
74,
Thank you.
page 438.
Yes, I have it, thank you.
The claim of restitution relies on the principle of unjust enrichment and draws comfort as a claim capable of being pursued within judicial review proceedings from the relevant decision of the High Court in Richardson and Worcestershire County Council, etc. Mr Lawson, as we see later in the paragraph, relies upon a specific reference to the local authority records which reveal an acceptance that there was no legal basis for not paying the transport and placement at fix and kicks. That was the specialist placement for the daughter. It wasn't a child, I think she was 22, disabled daughter. So it's plainly put on the foot of a restitution claim by my learned friend in the High Court. Then, if we look at the judge below's, the judge at first instance's discussion of the issues, we pick that up at page 442. Got it, paragraph 91, the nature of the claim, what they were claiming for. Then they deal with unlawfulness and unlawful remedies and so forth. So there was unlawfulness found. But it's the final page, or final penultimate page, at page 448, in which the judge below dealt with damages and or restitution, as he describes it. And paragraph 113, you'll see he hasn't identified any unlawfulness in relation to the local authority's decision-making process. Accordingly, for the most part, this question doesn't arise. But in any event, he goes on at paragraph 114. Again, I considered briefly the question of the claim in restitution on the hypothetical basis that I'm wrong on the issue of unlawfulness. He doesn't regard the Richards case as providing persuasive authority that monetary damages claims are capable of being pursued in public law breaches, etc. And then goes on between C and D. The facts are somewhat unusual and the circumstances specific to the case. It seems to me that Mr. Lawson acknowledges that any monetary claim would have to be based on in restitution as opposed to pure damages representing losses. In other words, relying on the principle of unjust enrichment. And so it's plain that as can be that it was a restitution claim, although the submission on behalf of the ICB in the court below that it wasn't a restitution claim. So we look then at the Court of Appeal judgment behind tab 19, starting at page 487. And you'll see from the holding at 488 that the court determined that the judge below had erred in determining that there was a minor breach for which the claimant was not entitled to compensation for a financial position remained less than it ought to have been, and accordingly the local authority is liable to compensate the claimant for her accrued right to the cost of her attendance at the identified establishment during the relevant period. Now this, as you see, is the judgment of Lord Justice Haddon Cave, with whom Lord Justices Moylan and Flo agreed. We'll see at page 501 the issues that the court was considering on the appeal. Paragraph 53 towards the bottom of page 501. 5 issues for determination, and it's over the page. Issue 4, cross appeal. Should the judge have held that CP's father in litigation frame could not pursue a claim to secure public money to be paid to him for CP's use of X, Y and Z premises. The court goes on to find that there was, in fact, unlawfulness in that case, and then goes on to consider and with respect to the judge below's contention or finding that there was the breach was only in a very limited respect, Lord Justice Haddon Cave says at paragraph 82, page 507. In my view, the judge's approach and decision on this basis was wrong and heterodox. A breach of a statutory duty is a breach of a statutory duty. It is by definition unlawful conduct. In the present case, having found the council in breach of its statutory duties, he should have gone on to hold that the council had acted unlawfully and accordingly was liable in principle to compensate CP in respect of any monetary shortfall. He then goes on to consider the council's argument, what we learned from Mr. Lockwood contended. And importantly, if we go to page 508, we see at paragraph 87, Mr. Locke argued that CP's father in litigation was the real claimant in these proceedings and was in effect using the proceedings inappropriately to profit from the claim. Since DA, which owned XYZ, was a charity organised and controlled by him, in my view that argument is misconceived. There's no conflict of interest on the part of Mr. JP. Claim report in the name of CP because of the legal rights which have been breached and their legal entitlement to compensation for the council for failing to fulfil its statutory duty. Then at paragraph 89, fifthly, Mr. Locke further argued that there should be no recovery or relief in the present case because, as he puts it, breach of a public law duty does not give rise to private law rights. In my view, this argument is specious. CP is not asserting private law rights. And by that, he means not private law rights with respect to the restitution. It means private law rights with respect to the failure to provide the educational provision that underlay the claim in itself, i.e. the initial unlawfulness that the Court of Appeal had found. And then in the summary at page 509, you'll see 92 and 93, as the judge noted, at the heart of the case is dispute as to whether the council should have included the cost of CP's attendance to XYZ in her care plan personal budget from the moment when the plan was first drawn up, and whether the compensation is now due to CP to make good the period when this was not funded. 93, in my judgment, the answer is yes. Council's failure to ensure that the personal budget included payment for the cost of attending XYZ from the outset amounted to a clear breach which duty under Section 26 of the Care Act and its linked duties. Contrary to the submissions of Mr. Locke and the judge's findings, it was not a limited breach, and nothing that transpired thereafter extinguishes the council's liability to make good its breach. Accordingly, the council remains liable to compensate CP for a accrued right to the cost of her attendance at XYZ for the set out period, including that there must be compensation. So, true it is that the judgment doesn't analyse the compensatory award in terms of restitution, but there can be no doubt, given the way that the claim had been presented, that this was a claim for restitution on behalf of this family. Neither can there be any doubt that it was a claim for restitution of the payments made by the father on behalf of the care that should have been provided by the local authority if it had acted lawfully. We say that this is directly analogous to the present case. And the only...
How's it analogous? Because in this case you lost on ground 2.
Because we still found unlawfulness.
In a different respect. So you
in a different
not in the failure to provide after the 10th of July, but in the failure to have a care plan in place.
Yes, but the care plan was crucial.
Why?
Because the care plan was there to set out the care that should have been provided, and there was an obligation. The obligation on the local authority, on the ICB, was to provide the care that was set out in the care plan. If the care plan falls away, then that obviously infects the ability of the ICB to provide the care plan as set out in a lawful care plan.
But the ICP were going to provide the care even though they didn't yet have a finalised care plan.
But it was care. It was care that wasn't consistent with a lawful care plan.
That's a whole different point, and you've lost on that point. You've lost ground 2.
No, the ground 2 was where
they could cease.
Was whether it was rational to withdraw.
And it was rational. They were entitled to say no more in viva.
Yes.
Because I've not seen anything that you've argued to date to suggest that what had to be in the care plan in order for it to be lawful was that Enviva should carry on supplying 163 hours a week or whatever it was.
No, there's no legal requirement for the provision to be made by any particular company. That couldn't be the case. The requirement is to provide the care as set out in the care plan. If there isn't a care plan, then it can't be assumed that whatever was going to be provided would have met the needs of the child, because there wasn't a document or an assessment setting out what the needs of the child and how those needs should be met.
But the ICB acknowledged that. Their whole point was that they'd been pressing Enviva for a care plan and there wasn't one. So it must follow that if they had been allowed to put in nursing direct, that a care plan would have been put in place. Why isn't that the case?
The care plan didn't set out, the care plan that was under challenge here didn't set out the hours and qualifications and type of care that was to be provided for this child. That was the point that we made a few moments ago, if you recall. I read out
that wasn't the basis of the judge's finding.
I did it in very short order, but and I did it necessarily quickly. But if your lordship recalls, the care plan doesn't set out how many hours of care.
Yes, you gave us a whole list of things.
Yes, absolutely. Now,
you're now advancing a positive case, and not the negative case that it failed to meet the standard because it didn't have those things, which I think is ground that we've covered. But I think you're putting forward a positive case that it ought to have included a number of things, effectively to mirror the care plan that was in fact put in place post 10th of July, so that you would, and somehow that's wrapped into the success that you've had on ground 1.
Well, the care, the care that was in place wasn't consistent with a lawful care plan. It was provided in close cooperation with the family, but the care that's been provided for the child since the 10th of July of last year is very different than the care that's qualitatively different than and quantitatively different than the care that would have been put in by the ICB from that point onwards. And indeed, the mother refused to have that because of the risk that it posed to her child. So the court's right when they say that, well, the ICB were prepared to put care in, but we don't know what the care, absent a proper analysis of the needs of this child and how those needs are to be met, we've no idea that would have been adequate.
We've no idea whether the care that was in fact put in after the 10th of July
But
was
that goes
proper or adequate or exceeded what was necessary, and we don't know.
No, we don't know. No,
We have no evidence at all.
absolutely. But what we do know is that was what mother and father put in place to ensure the safety of this child. That's not a situation that any family should be put into. That's the obligation of the public body to.
Well, I don't think we. I just was. It's the point I made to you right at the beginning. I think what we're interested in is how that submission, the submission that your client's entitled to restitution of money expended after the 10th of July.
Yes.
How that hinges on the best you can do, which is to hold the breach on ground one,
Yes.
which is a failure to have an adequate care plan in place.
Yeah. Because
how
if
those
there's
two
no,
connect.
because if there isn't an adequate, there's a necessary nexus between a care plan and service provision. That must be correct, obviously. If there's no lawful care plan, it can't be assumed that there's lawful care or adequate care being provided. And that, in a sense, goes back to the Court of Appeal, this court's
We've
decision
not seen that adequate care was provided. I mean, we just don't know what went in after the 10th of July because your clients were in charge of it.
Yes, necessarily.
Who knows whether it was right, wrong, or indifferent? We're not in a position to decide.
No,
that.
I'm not. Well,
And certainly the judge didn't.
Well, you're not being asked to.
You and the judge
my
didn't
lady.
touch it.
I wouldn't do that. What we do know is there wasn't a lawful care plan in place that sets out what the needs of the child are and how they're going to make.
So you're advancing a restitutionary claim for the £350,000 that have been spent since the 10th of July, consequent
Yes.
on a failure to have a care plan. And I suppose, maybe we've been round the house, but it may be said that it's difficult to see the connection between those two things.
Not at all, my lady, because the family were put in an invidious situation. They had no choice but put the care in place to protect the life of their child. And in a sense, that goes back to the point made by Lord Justice Haddon Cave in the CP case, which was that it wasn't a limited breach in that case. A breach of a statutory duty is a breach of a statutory duty, and by extension, we say the same applies in this case. There was a breach of the duty. We say unquestionably, certainly on the findings of the judge below. In that case, it gave rise to a claim for restitution. But then we have to consider what the purpose of restitution is. I was going to come to this in a moment, perhaps consider it now. I was going to take the court to Lord Reid's judgment in the ITC case, if I may. I'll do it at one point. But Lord Reid refers there to corrective justice is a phrase that he uses. I can't remember exactly what the paragraph is. I'll take it. I've got my notes. But he refers to an underlying principle of the remedy for unjust enrichment, that restitution is being corrective justice, and that must be to put the paying party in the same position as it would have been if the receiving party or the benefiting party had acted correctly. So this isn't a straight transfer of money, obviously. So I'm saying the benefiting party. So the restitution here should put the paying party, that's the family, in the same position as it would have been if the benefiting party, that's the ICB, had acted correctly. Now, if they'd acted correctly, had a proper care plan, none of this would have happened.
Well,
Now, it may be, so if I can just pick up a point that my Lady Justice Whipple has made, it may be that the restitution, the consideration of the quantum of the restitution, is a different thing than the principle of the restitution, and whether restitution is appropriate in these circumstances. But this court isn't being asked to do that. We've always made clear that the actual working out of what restitution is owed is not a subject to this appeal. It should be sent back to be considered. Hopefully it will be resolved without further troubling the court. But that doesn't go to that's a different point.
Just put it again. I think the problem I have is that your submission rests on what I think is a giant assumption, which has not been demonstrated by evidence, that the proper care plan that would and should have been in place would in fact have reflected precisely the care that was in fact provided on the 10th of July. And I think that's
in essence, Milady's putting my client in an impossible position there, because they can't prove that. Okay. It's not in their gift to do that.
You're asking us to assume that.
No, but I'm asking the court to assume that there was unlawfulness on the part of the ICB that led to there not being a provision in place that met the needs, the very profound needs of this extremely disabled child. Sorry,
No, not at all. I think we're just trying to work through it together.
I understand that entirely, yes.
Ground 2 was you did not succeed on, and that the judge declined to hold that the decision to terminate the then current registered care provider's contract and proceed to replace them with a new registered care provider was not irrational.
Yes.
Right? Now, surely, if there was no adequate care plan in existence or proposed to be available, how could the judge have reached that finding?
Because, and that was a submission that we made to the court.
Well, that's what I'm worried about, is because you're now, in effect, well, you're trying to now say, or now submitting, and as you're entitled to do so, that actually the care plan was completely defective anyway, which I don't find that in the judgment. And secondly, how it interrelates with the fact that you didn't get home on the second issue.
2 points there. It's paragraph 51 of the judgment where he says what our submission was, but then says he didn't need to deal with it because he decided to focus on the primary, the first point. I'm pretty certain.
Yeah, he does. He says it's not necessary to examine the detail.
Yeah, and so you'll see the reference to the cases I've just.
And we've looked at them together.
So we did.
And I wasn't suggesting you hadn't run it. I was just saying we didn't have any findings about it.
Oh no, of course not. Of course not. And you see why the judge did that. But when you analyse the judgment in the succeeding paragraphs with respect to ground 2, he found against us not on what we said was the primary point, which is what your ladyship focused on, which was withdrawing the care plan without there being a lawful care plan. The judge's focus was on the efforts that had been made and the incessant toing and froing that had gone on, and the exasperation, frankly, of all concerned as to what had gone on.
If you're right about the nexus with the care plan, surely the judge would have had to say, deeply frustrating for the local authority, but I'm sorry, if there wasn't a proper care plan, they couldn't.
Well, that was our submission, but he found.
Didn't succeed on that, and there's no appeal against that.
No, but he found that it wasn't irrational for other reasons, not for that reason. He didn't say that it was rational to withdraw, to turn that argument on its head. He didn't say it was rational for the ICB to have withdrawn care in the absence of a lawful care plan. He said that it wasn't irrational to withdrawn, given the toings and froings that had taken place, which is a quite different thing. And that was the judge's perspective on it, and we're stuck with that, and that's what it is. But we come back to the point that it's not a limited breach, as this court had considered in the CP case. It's an important breach, and I take my lady's point that we just don't know whether the care that could have been provided would have met the child's needs. It wasn't a very promising start when the agency went round and said and had no information about the child at all, didn't even know his name. We've got that, and one has to put ourselves in the shoes of the family. What were they to have done in these circumstances? And they've been forced to make the most
Again, we go
enormous
back to ground
sacrifice.
2, which is the judge says it was acceptable, reasonable for the
CB.
ICP. I always forget the acronym. For the ICP to
B.
have
ICP, yes.
to have terminated NVIVA's
Yes.
involvement,
But that was
which
because
necessarily means
but that
it
was
was
the point.
acceptable for nursing direct to go in.
No,
Acceptable for
no,
nursing
no.
direct to
He
go in.
wasn't saying that at all. What the judge below were saying that it wasn't irrational in the circumstances because of the efforts that had been made to put a care package in place. He wasn't saying that it was rational to have withdrawn care in the absence of a care plan. That's not the rational. That's not the reason the judge came to that decision. Albeit that you'd be invited to do so.
He would have decided that if he was with you on that, he would have said, well, maybe it would have been okay to say NVIVA must end, but in light of the fact there was no care plan, it wasn't open to this
Well, he
defendant
could have
on
done.
this day
Certainly
to
could.
withdraw NVIVA's involvement.
Certainly could have done, but he didn't.
He didn't.
No, absolutely. But he doesn't say to the contrary anywhere in his judgment either.
Well, he does say that one of the reasons why it was not irrational to dispense with NVIVA was their failure to provide an updated healthcare plan.
Yes, absolutely, my lord, and that goes to the exasperation point that I was making. I don't know whether that's the right word or not, but I think that summarises.
So he knows that there is no up-to-date plan in place.
Yes.
And if
Oh, yes, he knew. Of course, he knew that. He dealt with ground one, so he'd seen what was said. When he found there wasn't an up-to-date plan in place. Problems with NVIVA was about the use of agency nursing staff, wasn't it, and whether they were registered with the CQC. That was the difficulty there. So we say that yes, it is an error of law not to have had an unlawful care plan in place. A, B, that in those circumstances, the care that should have been provided by the ICB had to be provided by the family, and C, they should be.
Sorry, let me go to say it was unlawful not to have had a care plan in case it followed that. Is that your submission?
Yes.
The family had to self-fund. Is that right?
No, had to put care in place.
Had to put care in place.
They paid for that care, and as a matter of law, they should be recompensed for that. Now, it's not a matter of discretion, as we've seen. They should pay the difference between what the amount that the appellants have paid to and the amounts that the respondent has benefited by. So that's.
But the judge makes no finding, does he, that it was either unlawful or irrational to propose nursing direct?
He doesn't get into that. No, he doesn't get into that at all.
Well, on the contrary, he says that the ICB made strenuous efforts to work with the parents to put in an alternative provider.
Yes, yes.
And the parents weren't prepared to have that.
No, and the reason for that was because the providers that turned up on the 10th of
Well, I know they didn't know the child's name, and that's very unfortunate.
Well, not just
I can
didn't know the
understand that, but the ICB did say, all right, you don't like that particular person who turned up. Let's put that person to one side and let's try and have a fresh start and sort it all out. And that didn't happen.
Yeah, but that illuminates the real problem in my submission, my lord, and that is that there wasn't a lawful care plan in place that could have been picked up by an agency, and the provision made, the right number of hours, the right number of care staff, the right qualifications, the right number of nurses, etc., etc., etc. Now, we're not here to determine the details of that, that should be done by the professionals, obviously. But that situation arose because there was no lawful care plan. Now,
is that
as the Court of Appeal...
Is that a
Oh, sorry.
No, not at all.
I'd appreciated the time. Yeah, I'll be about another quarter of an hour, I would think.
Certainly. I'm sure Mr. Lawson will be relaxed about that. Thank you very much. That's most helpful, Mr. Wilson. 2 o'clock, please.